myself. I don't want to expand a lot on what Lucien already said. But yes, I was participating in the Moot court 2 years ago, and thus it's maybe a kind of a speciality or something irregular for you compared to the last days, because usually you had some practitioners and lawyers who are already with like 10 years of experience in their field. I guess once you had the session by Anza, that was also conducted by a bit of a younger lawyer, but compared to Anza, I'm even one step behind because I'm also, as just you do, pursuing my law studies. I'm still working as a research assistant alongside finishing my law studies. And maybe that makes it even a bit more interesting to you, because at some places I might be able to relate a bit more to you. And especially on this topic of mastering memoranda, I guess that's really, really important. I will give some introductory thoughts before going to the slideshow in a second. But maybe just to the background once again. So on one hand, yeah, I'm a student, as all of you are, as Lucianus and so on. But I was lucky enough 2 years ago also to participate in a quite strong team from the University of Freiburg in the Vis Moot, and we were able to draft back then the best memorandum out of like 400 approximately in Vienna, which was then awarded as best memorandum. And I was really not able to draft anything as to legal text before I was starting with the Vis Moot. So all I learned and all we pursued was coming in this process. And it was a long way. It was a really, really tough way. And that's what I wanted to say already up front. It's for sure no like conclusive way. It's nothing that is now finished and now I'm able to draft a memorandum in a very professional way. I'm doing that now for 2 years, and I still find so many mistakes. And if other people look at my drafts, they can find so many mistakes. But maybe to calm you even more down, when I did my first internship 1.5 years ago in an arbitration firm, the partner, one of the most distinct European arbitration practitioners, told me that he's now drafting his own memos for 30 years. And he considered it to be a masterclass that he himself really did not master or finish for himself at all. So it's really a process. It's like an art form where you just have to get into it more and more and more. But, and that's now the good part, and that will also lead us to these upcoming slides, it is also something that you can break down, that you can systemize somehow, and where you can make your life much easier if you just have certain things in your head. So that being said, I guess we can jump right into the presentation, Mastering Memoranda in the Vis Moot. And to explain the topic, maybe why it's that specified, writing memoranda by themselves does not change. Like lots of the thoughts that I'm going to present to you are applicable to any kind of legal drafting. But on the other hand, you already heard, I guess, in your second session conducted by David, that there is quite a close interconnection between moot courts, especially the Willem C. Vis Moot, and the actual world of arbitration. They are really looking for talent within the Vis Moot. And so this might be the most interesting moot court for you to participate in. And it has some particularities as each competition has, that we are going to take a deeper look into. So that being said, we are basically going to do two things today, and they are kind of overlapping. We are first going to take a look at the content of a memorandum in the Vis, and then we will take a look in like advanced effective drafting ideas. However, of course, also in the first place, we will not just like say what is part of a memorandum, but rather we will also say how to make this part good. Excuse me. Okay, so let's start with first the content of a memorandum. And here the ideas to guide you once through a whole memorandum, the winning memorandum that we drafted 2 years ago. Just that you see already right now what is all awaiting you. I guess that's something that might calm you down quite a lot, because none of us probably has ever drafted something that complex. Give me 1 second, I'm a bit fighting with the cough. Okay, drafting memoranda. So first of all, excuse me, the years here are wrong as I just see, but the dates are right. You are going to have a course if you participate in your moot court. And for you, that will mean that on the 11th of October of 2024, a problem will be released. And then, like approximately 3 weeks later, 4 weeks later, there will be one step where you can ask questions as to that problem. I guess maybe Eric told you about that already when he was telling you about the Vis Moot itself. Then you have, after a few weeks, a submission deadline for your claimant memorandum, and that is followed 5 weeks later by a submission deadline for respondent memorandum. And we are right now taking a look at for exactly those two parts to prepare you for your drafting period during the LMC Vis Moot. So what are we going to cover? And that's maybe something that might be interesting for you up front. So we are going to talk about the grading system of the memoranda, how they will be ranked in the competition, how judges will establish whether you have the best memorandum or maybe the 100 best or maybe the 380 best memorandum. We will take a look at the singular steps, just that you have built some security, that you already know what you're going to expect. And then we will talk, as I said before, talking about how to do that more effective, about the respondent memorandum, how to do that maybe specifically then from another perspective. And then we will talk about the more advanced points. So why to start with the grading system? My idea to start with the grading system is sort of that everything I'm going to explain now afterwards has to be filtered by your thoughts from this first slide, because you want to be a good participant, you want to be successful. And to be successful, you always have to understand the game. You have to understand how to be successful, not only how to be good, but how to find the shortest way to success. And for that, we have to understand how it works here, how the memoranda are graded, to have an understanding what kind of main points and specifications we have to set, where to put attention to in drafting a memorandum. So first of all, it's basically working in 2 rounds. First of all, you have the first round, where all of the submitted memoranda drafts will be sent to different arbitrators. These are judges, these are lawyers, these are arbitration practitioners, usually quite distinct, that are going to read your memorandum. Additionally, also these memoranda will not only be read by 4 arbitrators, but also each arbitrator will read 4 different memorandum. So that might already give you some understanding that probably these arbitrators will not have so much of time to take a look at your memoranda. Because as you might expect, arbitrators, lawyers are quite busy people. They are working usually much more than 40, 45, 50 hours per week. And then taking time in the evening to read memoranda, to read work of a fictional competition, is something that not everybody is able to do. That's something that you have to have in mind while drafting your memorandum. We will see that very often right now in the next slides, but the key idea that I want to deliver here is that it has to be easy. It has to be something that a man or woman wants to spend time on afterwards, after its work. And that's also enjoys the experience and should not take too long to understand what you want to say. But we will come to that in a few slides. The second round then is quite limited already, because from all of these memoranda, only 25%, only the best of these 4 graded within one pool, will make it to the second round. And there we have a separate jury of very distinct lawyers from all around the world, and they will evaluate those left over. It depends on the number of teams participating, but in between of 50 and 100 best memoranda, and then they will be actually ranked within this sphere. That is not that important. There is lots of also like subjective points involved, but this first round you really have to have in mind while drafting a memorandum how it works. So what are the criteria for evaluation? First of all, according to the Vis Moot rules, it's the quality of the legal analysis, so your actual pure legal understanding. Second, it's the persuasiveness of arguments. Does your argument make sense? Is it like common sense? Do the facts speak in your favor? If I listen to that as a non-lawyer, do I think you made a decent point? Or is it something that only a lawyer might uphold as a good argument? We might think about certain examples. It's about the thoroughness of the research, so not only about the clearness of your legal analysis, but also about the whole broadness of your research. How much sources do you use? How good of sources do you use to uphold your arguments? In the legal world, we are always discussing authorities. Usually our own ideas are not really respected. The ideas of some distinct professors or courts are respected. And we have to be smart enough to use them in our favor so that these authorities speak exactly for our position and thus also shine on us. That's meant by thoroughness of research. The style of drafting. What is your writing skills? Do you have some consistency? Is it fun, entertaining to read what you are writing? Is it consistent? Or does it seem like it's a bit sloppy? Does it seem like there were lots of different people working on it in different time spans? And in the end, we don't have a properly styled draft. And then it's about the clarity of language and writing. We will come to that point in detail. But basically, it's about simplicity. It's about unequivocability of what you're writing. Is it actually just being able to be understood in one way? Or is it what you are saying being able to be understood in 2, 3, or 4 different ways? That's nothing you want as a lawyer. You want to be very clear, and everyone has to understand the exact one point that you want to make. And of course, also your language skills are a precondition to reach that goal, to make exact, precise statements. So from that technical point, we will now come through a bit of another technical slides, but I guess it's interesting to just once have a bit of life in all of these words, memoranda, draft, and so on. When I started the Vis Moot, I was not working in a law firm before, so I did not know a lot about any of this. So I guess it would have calmed me down to once see what I shall expect from the next months. What I want to say up front is that within this grading system, we have now also the style of drafting, as you see. And that means that the document that you're going to deliver in the end of your deadline has to be perfect from A to Z, from alpha to omega. It cannot have mistakes in there. We will talk about that in a second, or consistently. But it has to make a very professional appearance, and that starts with the cover page. That's nothing that should be underestimated. This is the first thing that some distinct lawyers, after 10 hours of working with big clients from all around the world, with states, now sitting at your student work, are going to see. And if they see something that looks maybe like this right now, or just professional, you can see lots of examples, that might be something that they're interested in opening. And if they see just, I don't know, a sloppy cover page, maybe not even a cover page, they might already have a very bad gut feeling in opening your memorandum and reading your arguments. And that's very decisive, once again, thinking about the grading system, thinking about the limited amount of time they will have for your draft. So what we have there is basically very formalistic. The name of our university, the logo, and everyone does the same if you are a good practitioner and participant. We have the title of the document. In that case, it was our memorandum for the respondent. We have the name and the address of the parties. So you can see here, in this case, the respondent, our client, and then here the opposing client. In that case, it was drone IPLC. That was, as I said, from 2 years ago in the new problem. And then you have here the name of the authors. As I said, I was lucky to be part of a good team. I did not win this award by myself at all, but here I was also playing along. And like this, it once again might already deliver a good first impression. The second thing that we are seeing is less technical, even it might seem to be technical as well, and it's the table of contents. The table of contents is absolutely essential, and it's expected by all of your judges. If you don't have it, you will not be considered to be in submitting an academic piece of work, and that's really the approach that you should have to your work. It has to be a high academic standard work. So of course we need a table of contents, and we don't only want to see in the table of content what we are going to talk about. We don't only want to see a summary of like points or bullet points, but what we want is providing a clear understanding, a clear structure of our whole main logic. So basically, once again, we imagine the busy arbitrator coming back home after work from office, and he will open your cover page, turn it around, and then he will see your table of contents. And what he will do for sure is spend 5 minutes on that table of contents to understand whether by reading these headlines, he will understand what you're going to say. And then he will be interested or not interested. This is really extremely, extremely important to structure your memorandum step by step, and we will come to that also later, so that always you have headlines that link to each other and that then are depicted within the table of contents. And you can basically, once again, understand the whole 35 pages of text by just reading these 2 or 3 pages of table of contents. That's a very high goal. That's very hard to achieve. And of course, the details are provided then in your actual draft. But if you really want to be successful, that's what you're striving for. You want to facilitate, of course, also a convenient experience for your judges. So what is quite common is that they are not reading your whole memorandum in one line. They might stop at point B, and then they will continue next day on point C, because they don't have time to read your whole memo in one evening. So, for example, what some universities are doing, they will see it online, is including hyperlinks in this table of contents that you can directly jump to the specific headlines and so on, just to make it more user-friendly. We have to think how to satisfy our judges. That's our main goal when we participate in any competition where we want to convince our judges. So once again, I already said that the outside impression matters a lot. I guess I don't have to repeat this. But really don't underestimate this. It's extremely important to see your logic, and it's not just a formalistic thing to have a table of contents. Then you will have indices. And here we come to our point of grading system. Now you see why I put that slide up front, because I want to come back to that close to each slide. As to the grading system, we had the thoroughness of research. And of course, we can see that within the text. We can see how many sources we cite in the text. We don't use footnotes in the Vis Moot, but we use like squared brackets after the specific argument to cite our authorities. You will see that in the next slides. But where you can see that much better is in the indices, whether someone has 2 pages of sources or whether someone has maybe 15 or 20 pages of sources. I can say it for all memo, we had, I guess, 48 pages of sources and then 35 pages of text. So much more sources than text. That does not have to be the case, but it also has to be like a certain minimum level. And to see that lots of scholars and lots of courts uphold your position, is that what is going to convince your judges. So spend time on finding lots of sources first, but then also organize them once again in a professional manner. What I mean by that is, please apply a uniform format. It's really quite common to see different fonts being used. Like once is Arial, once is Times New Roman, once it's Calibri. That's once again really unpleasant to read. We don't want that. It does not seem to be professional if we have it. We see sometimes that people cite the title first and then afterwards the edition or the place of distribution. And then on the next source, they first have the place of distribution and afterwards the title. So we're just like wondering, why did they do it like this? What I mean by that is, once again, be consistent. Agree with your team, with your other members on certain standards, and then be completely rigorous in upholding these standards. You don't deviate from these standards. And you will see that you will deviate from these standards just by the human factor, by usual errors. And it's your task to notice these errors and then to, iron them out, I would say, to bring them once back to a uniform format. Exactly. Well, what kind of indices do we have? We have an index of literature. That's all of the scholarly opinions that are in favor of us, professors, commentaries, and so on. Also, practitioners often release such sources. That's all part of the index of literature. Then we have our index of cases. Here we talk about litigation cases, more precise, actual state court litigation. So we have court judgments that we use in our favor. And why do we do so in the Vis Moot? Because we are talking about international arbitration. Because we often derive arguments from general principles that apply uniformly across the globe and thus might be also applicable to our cases. So that comes to the index of cases. Then we have an index of awards. Here we don't have actual state courts, but we have arbitral awards, and that might be even more persuasive, because once again, that's even closer to our case, just as to the method of dispute resolution. It's also arbitration. So we might think that's also more convincing to use it in our favor, because we're also in arbitration right now. So there are more links, more connections that help us. And here we have then usually lots of ICC awards from the International Chamber of Commerce. We have awards from the Hong Kong Arbitration Center. We have awards from the Singapore Arbitration Center, from all different centers, or also ad hoc awards that you can find. What we have to conclude is an index of legal sources. So there's all of the codes that you are using to make your points. That's usually, as you heard already, I guess, the CISG, Convention on International Sales of Goods. It's usually the UNIDROIT principles. It's usually another procedural talk. For you, it will be the Finland arbitration rules. And it will be the PICC, the principles on international contract and commercial contracts. Sorry. But also additionally, you might use some international conventions and so on, the Vienna Convention on Law of Treaties you heard about yesterday, Nikla's session, if I'm not mistaken. All of these will be abbreviated in your memo, because you don't want to write lots of text each time naming these conventions or codes, legal sources. Otherwise, you would have less space to make material arguments. So you will just use abbreviations, and your legal sources then will explain that in the index of legal sources. And the same applies for any kind of different abbreviations. For example, you might use the business incorporation form if it's a limited company or public holding. So if limited, you would use LTD. That's quite self-explanatory, but sometimes you might also come up with abbreviations that are not that logical, that are not that widespread. Maybe some that you are also inventing for yourself because of the particularities of the case, for a specific kind of contract, for specific kinds of clauses or so. And you're using them again and again and again, and you would use lots of space. So you agree once again within your team to consistently use abbreviations in favor. And then you can upfront have an index of abbreviations that explains all of that. And that's basically the 5 indices you should have in your memorandum. Here I have a counterexample that's maybe interesting. So that was our memorandum. That was the memorandum we received and we had to answer on. You can see here exactly what I mean by uniform application. So we have different fonts, 1, 2, 3, 4 different fonts. We have different stylings of the fonts. Here it's bold, here it's all caps, here it's usual. We have missing full stops often. We have typographical errors. I guess it's really self-explanatory that this might seem to be less scientific than this, and maybe the content is the same, but you already develop a certain gut feeling. And once again, being in the shoes of the arbitrator, that is very decisive. But okay, now we finally come to the part that we're actually working on, and that's our arguments. And we start our arguments with a so-called statement of facts. The statement of facts is quite important usually, because it is building the outline of what you're going to talk about. Basically, the statement of facts is a summary of what happened. How would you explain your grandma, your non-lawyer friend, what happened? That's basically the idea of a statement of facts. So what we are doing here usually is having some very general introduction. How did the parties first meet? What was the parties' relationships? What kind of connections did they have before the dispute in between of them arose? And then we have basically a timeline. That's the most common way to do this, and I would recommend you to do this as well, which goes then for 1 or 2 pages, explaining very easily, step by step, in a chronological manner, what happened when, to give a clear understanding to that. There's one saying, it says, "Dami fakta davut use." It says like, you give me the facts and I will give you the law. So basically that's the idea. A judge needs to know what happened. And often in arbitration, the legal question is rather easy to answer, but the factual questions, they are really crucial and decisive. So be aware of that. Use also your chance to write a statement of facts. You should definitely do so. And also use this chance for some subtle framing in favor of your party. You want to convince, you don't want to trash talk. So you want to seem objective, you want to seem concise, you want to seem like someone who's actually just doing a summary of what happened. But of course, it might be convenient sometimes to leave out that one fact and to maybe put a bit more emphasis on another fact, because it's actually more in favor of your party. I guess you see where I'm going to. So use this statement of facts, these 2 pages, to make some very subtle, professional framing, storytelling in favor of your client, so that the judges will think, oh, wow, from all of that, what happened? I don't know the law right now. I have to read the arguments. I have to do my research. But from that story, my gut feeling tells me they should have right. That's your idea of the statement of facts. In a mood, we will keep... Yeah.
So, sorry to interrupt you. We have one raised hand. Are you okay with receiving questions during the presentation, or do you want to...
I'm super happy about questions. Thank you. I was not telling that up front. I'm super happy about questions.
Farigis, go ahead.
Hi. I'm sorry for interrupting you, but I have one question. So I had an experience in like participating in Vis Moot. And one thing that I wanted to ask you is, I've read so many memorandums, and I saw that while, for example, you're writing on the procedural or merits part, there is one sentence, and after the sentence in brackets, most of the teams include some cases, awards, like thoughts of the prominent arbitrators, and there are so many of them. So what do you think? Is it good to put in brackets so many of the professional arguments and awards, or there should be limitations?
So I understand your question, whether you think like more is always also better. Is that your question? Basically, yes. So that is an interesting question, and there we come already to our starting point, that drafting memoranda is sort of like an arts form, where you cannot say like this is the objective right way. But the school that I was taught, and also our approach at Freiburg, for example, and also at Herbert Smith, is to really use all of the sources you can find in your favor. Because what you want to achieve is a expectation, an impression on the reader, on your judge, or in the actual world on the arbitrator, that it's not only you and not only this one court and the other scholar who is saying that, but that it's actually uniformly accepted. That this and that point is actually like that's not possible with each argument for sure. With lots of argument, especially in a moot problem, that's not possible. But some of your arguments will be very general. Some of your arguments will allow that. And our approach is that actually, as you just said, to have everything we can find. To facilitate in the team this, we, for example, were using a list, and each day after working on our research, we were making like points or collecting points for each source that we found, and we called it like the wall of shame. And the person that had the least sources in favor of their issue had to bake a cake for guys next month or something like this. We really want to have lots of sources usually.
Janis, can
Thank
I
you. And
just...
one more question.
Oh, Farangiz,
Yes,
go ahead. I'll go after you.
Okay, thank you. So one more question is, when you're writing, did you have an experience like referring or looking to some arguments from the previous memorandums? Because I had some concerns, maybe because I've worked in a particular part and I had some concerns while researching on awards and professional opinions of the arbitrators. And I had an experience by looking at some of the memorandums by previous years and some of the awards. So did you had it? Is it good or not?
Yeah, I guess that's really an excellent maneuver. The Vis Moot Association provides a service for you, at least for the Vienna part, to always upload the winning memoranda. And usually the winning memoranda are really good work and lots of work. And as always, you can just learn by yourself by taking a look at some who already mastered what you want to learn. So when I was starting back then or selected for my team, exactly what you just described is what I did. I was going through the website and I was just taking a look at all of the winning memoranda from the last years that I could find, because I never saw such a thing before and I wanted to know how to make it good. So I was reading them, I was trying to establish a feeling of how to formulate these sentences, but how to structure arguments and so on. And that's a great advice that I would really put emphasis on. Read those who already mastered what you want to learn. And sometimes they will even already include legal sources that are also in your favor. Sometimes maybe an old moot problem was dealing with not the same issue for sure, but with a singular point, sub-point that is then maybe relevant for both of the issues. So definitely.
Thank you.
Janis, if I may, with the follow-up questions to the previous question of Farangiz. So you mentioned that you can use whatever source, if you have more sources, it's better for you. Do you think that there should be a limitation on the sources that you put on the one page? Like, what if the people have sources which may fit to 7 lines, 8 lines, 10 lines? Is it okay to put them there, or do you think there should be limitations on that?
I mean, the question that is underlying basically is a weighing question. You have a limited amount of space in your memorandum. You have 35 pages. And each of these pages allows you to write, I don't know, let's say, I really don't know, but let's say 200 words. And you want to make arguments, and these arguments are usually complex. They are really something that you have to think about for long. So you have to think about how to invest your space. And you can invest your space in saying legal smart things and having good arguments, but you can also invest that space in having authority in favor of your arguments. And very often I would say it is better invested for the authorities, and you will usually not have half of a page of sources. I guess the most that we had, and we really are usually very extensive in our research, is 4 or 5 lines of sources. That's quite extreme already. And then you will usually not have this. We also only do that for main arguments then. In general, it will more often be the problem for you to find sources, to rather have 2 or 3 sources that are fitting, than 1 or 2 sources. And then you will usually not have this. We also only do that for main arguments then. In general, it will more often be the problem for you to find sources, to rather have 2 or 3 sources that are fitting, than 1 or 2 sources. and you might only have one there or two, and you make an argument that there is a general principle in that, but you only have one source saying that, so maybe that's not a general principle. So that's, I guess, the problem that you will face more often than having too many sources. And of course, as soon as you think you made your point, at some place it's enough, so keep that weighing in your head. What is important, I want to say that here, is to have only sources which actually make your point. You should not just include more and more of authorities, and then maybe they don't anymore say exactly what you wanted to say by the citing that authority. That's really, really, really bad if an arbitrator notices that. So for sure, stay concise and precise in the authorities you want to facilitate in favor of your position. That being said, we can come from the statement of facts now to the summary of arguments or introduction. And that's basically one page where you're just going to, in a structured manner, explain what's going to follow in the next pages. Classical, you just have a very objective summary of arguments. What some universities do is kind of here play this like mood particularities to like competition and be a bit more creative. Tell like maybe a story, an idea that is giving a bit of a more vivid framework to the whole afterwards very dry, very legal arguments that are following. But I want to say that that's something that you should really like leave behind. That's very little priority. In the classical case, you will be quite busy in the last weeks, and you want to have a summary of arguments that explains all of your 4 issues that you're going to address in the mood problem. And you will have a short explanation on the main arguments, main ideas that speak in favor of the conclusions you draw within these issues. So you're going to have there a summary of arguments before finally coming to your actual arguments. So you see, writing a memorandum is not only writing arguments, but this for sure is the main part. The rest is all obligatory, and you cannot step off of any of those points nevertheless. So what is the structure? And I have now 2 different levels of structures. First, we have kind of a macro structure. So I mean the big overarching structure within your issues. And then we also have a microstructure, so a smaller unit where we think, okay, how to structure them singular thoughts. But I will explain that now. The macro structure is basically that on each of the issues, we start first with an introduction to the issue itself. In our case, for example, once that's a very straightforward legal question that you might also face. It's a classic in a mood problem. Do we have jurisdiction? Is there a valid arbitration clause concluded? You know all of these terms, I guess, until now. And then we discussed whether there is even like the power of the tribunal to give a binding ruling on that. So this was the question here, and what we were writing in the first paragraph were facts that are basically the foundation for the arguments that we are going to develop afterwards. So first part, introduction, facts mainly. Then we come to a roadmap. I will explain a bit more to that in a second. And then we come to the arguments by themselves before in the end having a conclusion of our issue. And then we have our second legal question. In that case, our first one was, as I said, this jurisdictional question. Then there was a second procedural question. And then there are usually 2 questions on the merits of the case. So then we guide to the next topics. Inside, we want to structure in something that you might already have heard of. The mood participants of you already, for sure. We call it IREC or the CREC as we prefer it usually. It stands for conclusion, rule, application, conclusion, or for the IREC identification instead of conclusion. What we want to do there is basically bring our sentences and our ideas in a core set of structure so that everyone who reads it does always know where we are, and that also facilitates that everything we write is actually a logical consequence of what we wrote before. Because we're lawyers, we're not just storytellers, we're not authors, we're not literature drafters, we have to work with logical terms, maybe like an IT guy. So everything that we say has to follow from something that followed, that was said beforehand. I'm sorry. What we are doing here is basically, and we have lots of examples following that now. First, say what our conclusion is. So here we have a example. Let's go inside here. The missing parliamentary approval invalidates the arbitration clause. That's our first sentence. Very short sentence. And it's our conclusion. It does not really, it seems like a statement so far. So we want to back it up. We have a rule for that. Our rule is that pursuant to Article 75 of the Constitution of a country that was here relevant, and contracts concluded for administrative purposes, state of entity can only validly submit, blah, blah, blah. So we have a certain rule. We have a legal test. We have a judgment. We have a scholarly opinion that says, okay, we shall consider this and that consequence if that and that rule is met. So we will articulate that rule. And then we will do basic subsumption, basic legal work in applying our facts, our specific facts, which we already announced somehow in the introduction, under exactly that legal rule. So in our case, then we will discuss whether the approval was obtained first, and then second, whether now it is also invalid. So we apply exactly the actual facts under the legal rule. And because then it might have fit, usually it fits, otherwise we will not write this argument, we will come to our conclusion, which was already our first sentence, and we have one logical construct. Let's go through examples of that in a second. You will see that I prepared some. But first, I was already dropping a word that is called road mapping. And is once again showing that our draft has to be really like it has to be self-explanatory. It has to be one piece of logic, basically. And what we are doing in road mapping steps and phases is always showing basically what kind of points are following. So if we have like a big overarching argument, then we will say, okay, this argument is only correct because of those two sub-arguments. Otherwise, maybe our big overarching argument would also not be valid. In that case, a roadmap might be, however, the tribunal does not have jurisdiction to hear the dispute as the arbitration clause is invalid due to lack of parliamentary approval, A. That's the first thing that we're going to address. And furthermore, the bribes most likely paid by the claimant invalidate the arbitration clause, B. Okay, so we have two different things that we are going to talk about in favor of our position that there's no jurisdiction. And now we have A, and once again, we do the exact same thing, but just on a deeper level. So we say the lack of parliamentary approval invalidates the arbitration clause, what we just announced. That's now our headline. And we say this is the case because first, it was never obtained, and second, that's also a missing part of logic. Thus, it is also, as a legal consequence, invalid. So we have once again a roadmap, a structure that we showcase here. And we always announce that up front to make it easy to follow our line of arguments and thoughts. And what you also will see by that is that now having all of these headlines, we come to exactly the table of contents that we were starting with. We come to a overarching structure that we can see by just looking at the headlines. So road mapping is extremely essential for your memorandum. So now let's take a look at some CRECs, and here you also see like one of our biggest blocks of sources as coming back to the previous question. Here we have, I guess, 5 lines of sources. So our conclusion here was, or maybe I can ask someone of you whether you can tell me right now here where our conclusion starts, where our conclusion ends, where our rule starts and where our rule ends, our application starts and application ends. If any one of you raises their hand, maybe Sen, you can help me with picking one. That would be great.
Sure. Do we have any volunteers?
Can I?
Go ahead.
Yes, perfect.
Hello, Janis. Thank you. I as I see, we have the sentence as a general principle of corporate law, a corporation is a distinct legal person. So we may say that this is introduction, and then we can say at the end, we see the sentence, while respondent is fully owned, it is a private commercial company and operates as such, etc. And it is a conclusion, or I'm wrong.
That's like a good first try, but it's not exactly it's not exactly the case if we think about our boxes. I can
We
correct
have
or
Madhyar.
advise them.
Can I try?
Perfect. Yeah, we have other students who have other.
Madhyar, go ahead.
So
Okay, so first conclusion is like, firstly, respondent is a separate legal entity incorporated as a limited company. It's our conclusion for the beginning. Then, as a general principle of corporate law, etc., it's our rule. This principle applies equally to a state, etc., it's our application. And the last sentence, like, while respondent is fully owned, I think it's gonna be the conclusion.
Perfect. I guess that's exactly the right thing. And I want to quickly reason that. I mean, it's not that easy to see that first. We will have multiple examples right now, but great analysis first for you. So exactly, we have our conclusion. Respondent is a separate legal entity incorporated as a limited company. We say it's a separate legal entity. That's the argument we want to make here. It's maybe also hard to see that without context right now, but that's the argument we want to make. We don't have anything in favor of that yet, so it's basically just a statement. So we say, okay, that's our conclusion because we back it up by something, and that's first the rule. And the rule is a general principle of law in that case, but in all ways it is something general. It's something that has nothing to do with our specific case. It's something that can apply to lots of different cases. And in that case, our general idea, or general point of law, is that we have a distinction in between of shareholders and parent companies and subsidiaries. That can apply to each parent company and subsidiary, not only to ours. And then we apply that. So as you perfectly identified, this principle applies. That's also maybe a trigger word that makes us notice that we talk about application. This principle applies equally also to a state-owned entity. And so on, which is in our case, the respondent, which is fully owned by Ecuadorian state. So that's then our specific case, our client under this rule. And that leads us to our conclusion once again. So great analysis. I guess having that in mind right now, we can do it even faster for the next one. Is there anything else? Otherwise, you can do it also once again. I'm sorry, I was not able to notice your name. But maybe once again, you can think here about how to structure only using the terms conclusion, rule, application, and conclusion once again.
Excuse me, Janis, I have just one quick question about the last Iraq. Yes, about the last sentences. Can you change the slides? Yes, about this. So we have cases, a lot of cases in brackets. So you just put the rule, you just say as a general principle of corporate law, a corporation is a distinct legal person, and then you write just all the cases that have the same rule. Yes.
So exactly, that's a good question. What we have here is first awards. That's a award by different arbitral institutions, and then we come here to courts. That's the UK court. That here is the English-Welsh Court of Appeal. That's a International Criminal Court, and so on. And then we have in the end scholars, and all of them somewhere hold within their ruling or within their scholarly work that we should always think distinctly about shareholder companies and the subsidiary. So maybe there was once already an argument raised, in that case, to give some practical context. It was the question whether we can directly sue the state because the state has more money and so on, or whether we have to sue the subsidiary. But we wanted to go directly to the state that was more favorable for our client. And that was something that maybe other law firms also tried already, or other clients in a dispute. And in these judgments, it was said, okay, no, that's not possible. They are distinct. And maybe you will find some judgments where there were different basis situations where it was possible. But in general, exactly as you said, we are doing our research. We are looking for cases where people already wanted to make this argument. And when we find, okay, they actually raised this argument, but the judge was able to deny it, then that's exactly what we want to bring in the field for our client and for our position. So all of these exactly we're holding, no, a company should be distinct from its shareholders. That's basically the idea here.
And won't the organizers say, or organizers of the Vis Moot, that there are like a lot of cases you mentioned, and because do they really like check all of these cases, all of these pages?
Yeah. So there are two things. First of all, the organizers of the Vis are not the judges. We have like a committee of maybe 20, 30 organizers of the whole Vis Moot. And then we have hundreds and thousands of professionals reading all of this. So it's a bit of a different committee, but that's not your question. It's really risky, and it's also a matter of honor. Okay, so three steps. First, it's really risky. And that's for two reasons. First of all, they can open exactly your judgment because they might think, okay, especially in arguments where you might think about stretching something, that might be something that is hard to find something on. And these lawyers are working for 10, 20 years. So if they read something and they find a judgment in favor of that, they were like, oh, I wanted to make this argument 3 years ago in my case, but I did not find anything. How can these guys now have something? So they take a look inside, and you are basically fucked because you're, sorry for the word, you're basically lost your whole case because you out yourself as a liar. You don't want to be a liar, then you're not convincing. The second point is that actually I'm now working in this field for only 2 months, actually in a firm, but I'm now thinking about that for 1.5 years. And already right now for me, it's really sometimes I see only this abbreviation and I know the case, not in 5% of the cases maybe only. But I see that and I know, okay, that was saying this and that. And if I work there for 5 or 10 more years, that will increase in the share. So it might really be the case that they see what you cite and they know the case. And they say, okay, no, that was not actually the case. And then my third point I want to make is also it's a matter of honor. You can always lie, but you don't want that. In the end, you want to submit a nice, it's a training for you as well. You want to submit a nice, persuasive, piece of work. So yeah, I would not do so. Sometimes stretch has to be debated within the team, whether it's too stretchy, whether it's actually, it can be applied. That's always on a thin line. You have to debate that. But something completely off is really not to recommend to use.
Okay, thank you. Sorry for disturbing.
No, I'm once again happy about these questions. So, is there someone who can here identify the CREC?
You didn't switch the slide. It's the previous slide right now.
Thank you so much. That makes it much harder. No.
Jalan, go ahead.
Oh, yeah.
Yeah, Jablonbeck.
As you saw that the conclusion located in the middle of the text, and it's begin with this communicative requirements are expression of the separation of powers. Is it true or not?
Not necessarily, but I see your point, and there we can already discuss the quality of drafting. No, it's in that case, if you maybe take a look once again at the whole passage as such, it would not be our conclusion because that's not our main point that we want to say. That's just
we have somebody.
We'll maybe take that in front. Yeah, please.
Oh, sorry, somebody go
Okay,
ahead.
thank you.
Well, I guess that's the claimant, or I'm sorry, that's the IRAC formulation, because firstly, it is an issue, like claimant implies the minister's approval and etc. Then it's a rule, like Article 75 explicitly states that, etc. Then in the present dispute, it's the application, and the conclusion is therefore the minister lacks the power to approve the arbitration clause its own. So I guess it's the IRAC formulation.
Yeah, perfect. So exactly right analyzed. I did not necessarily want to make a differentiation right now in between of CREC and IREC, because basically you could also argue that this first sentence until these squared brackets is just an introduction. It's telling us why we're talking about that right now. And then we come basically to our conclusion. Then you could also call it a CREC. In fact, the minister's signature cannot replace the parliamentary approval statement again. Yes, so that's our conclusion. And then you were exactly right analyzing it before. I saw that you raised your hand before that. Once again, it might help for you to analyze it, but also for you to indicate it for your judges when you're switching, once again, to use keywords. For example, in the present dispute, applying this and that, and so on. You will find points or words which tell the reader, okay, now we leave the rule, now we come to the application of the facts. Okay, now.
I'm sorry, I have a question. Can I ask?
For sure.
As I understand, it is more preferable to use the crack structure, yes? Or it doesn't matter which one to choose, which one to use?
As a strong fan of the crack structure, I would say yes, but no. You will find very much more distinct lawyers than I am who will tell you the IREC is better. It's a matter of taste. I would say to characterize it, the IREC is more neutral, and the CREC is a bit more punchy. It's a bit more, straightforward. It's a bit more aggressive, maybe, but slightly, very slightly. And I guess usually we try to be very objective, and thus maybe using such a structuring device, which is a bit more aggressive, might be a good technique. That's the reason I prefer it. You cannot say it's better. That would be just wrong as a statement. And maybe to conclude that point, you will not be great at better or worse because of using one of those. It's about using them then consistently, and it's really hard to do so. It's really, really hard. I will show you how hard that is by some negative examples. We don't have to analyze right now where the CRA and CR, because we just don't have them. I will just quickly read through it, and I will stop in the middle of it because you will see that it's not that structured. There was good faith involved on behalf of those that draw an eye in relation to the agreement and the explicit approval from Parliament. Ms. Porter's evidence supports this. Ms. Porter contracted COVID and thus was out of office when the parliamentary debate was due to take place. And then we can see that there's just an explanation of things that happened. There's not a rule, there's not a conclusion that we draw. So basically we ask ourselves right now, what do they even want to tell us? What do they want to convince us of? And that's a question you will never want to raise within the head of your judges. You always want them to know what kind of point you want to make right now. Otherwise, you are lost. So don't just write facts which are interesting, which are good for your position, but always do that within this CREC structure to make it easy for them to follow. Second example here, once again, I will start at 33. Matthias Herdigen has described the GATT is the most significant multilateral trade agreement. Mr. Diebold has described it as a cornerstone in different fields of international economic law, notably international trade in goods of services. You see that it's really, that might be interesting, that might be right now rules, but it's really not helping us with our position, and it's really hard to follow. Maybe we can see what they meant. Maybe we can spend lots of time analyzing and see, okay, that's even like, we can follow that after analysis, but that's nothing anyone wants to do. And let's come back to the grading system. We don't have that time. What we see here right now, to be fair, is just bad. We don't want that. What we want to see is really always consistency, always one step going to the next, as we have it in these, for example. And then we come back to our macro structure. Now we concluded our CREC X course a bit, and we come to our conclusion. And what our conclusion is, once again, and I really enjoy that part about drafting because I just enjoy logical, like seeing logic in things. This conclusion is basically just, once again, enumeration of the headlines and previous conclusion within the CREC that we were doing. So we see that our microstructure of the CREC right now goes in our macrostructure of our conclusion, and basically they have to mirror each other. They have to harmonize each other. So what we see here is then the parties did not validly conclude the arbitration agreement. First, our main issue question. And then we have our first argument. It was never validly obtained. That was our first roadmap A. It cannot be replaced. That was our second argument. If you would now go back to our table of contents, you could see exactly these sentences in our table of contents. And that's something you have to have in mind. That's really hard to master. That takes hours and hours and hours. But it works if you just keep working on that. And it will never be perfect. Once again, it will never be perfect. And in the end, that's now very formalistic. You have a request for relief. That's something you just have to add. You have to have it in mind for your 35 pages of limitation within the Vis Moot. But it's pretty often you can copy paste it from the problem. It's basically just, once again, what you ask the tribunal to do. We don't have to go deeper here. That's not priority, but it's a mandatory part of your memorandum as to the rules. Now we come to a speciality. When we come to our second phase, the respondent memorandum. Basically, all I said right now also applies to the respondent memorandum. And if you apply all of that, you will have a very good respondent memorandum compared to all other participants. However, in a respondent memorandum, it's not only about, let's explain it that way, objectively going to the highest level of truth and then telling this truth, explaining this truth. Rather, it's a much more concrete case that we are right now in. There's a dispute, and there's someone who wants something of you, a claimant who claims something of you, and you don't want to establish eternal rules and eternal wisdom. You want to defend your client that these claims are just not grounded. So what you're doing is answering. You have to be responsive. You will address the points raised by the claimant. And usually you will not address more, but sometimes you have to. If you have a bad memo, then you have to construe it. They might also have argued this and that. They could have argued this and that. Maybe you find some sentences which indicate certain arguments which they did not actually make, but which give you sufficient grounds to answer on that. Because usually you don't want to just argue in the emptiness. You want to argue on a previous argument of the other party. That's what I want to make here as a point. You have to be responsive. That's also reflected in the rules. The picture I just here have is a excerpt of the Vis Moot rules that you can also find online. And it says it's the absolutely essential criterion for evaluation of a memorandum for respondent to be responsive to all the arguments made in the claimant's memorandum. What that means is that, as I wrote, the bad claimant memorandum might give you the impression now I'm winning the case, I'm better than my opposing counsel, but also realistically, it will just be a disadvantage for you because it will not offer that much of grounds that you can push into. If you have a very professional claimant memorandum and you are putting in lots of work, you can win the case then in favor of your party. That will be a much more broad analysis of law. And coming back to our very first slide, the grading system, that will be an advantage for you. Now, before coming to my second part, the effective writing, the advanced part, I would like to hear from Lucien how the time is going right now.
We have 50 more minutes.
Okay, great. Then we will do that fast. Give me 1 second because I have to charge my laptop. I will do 30 seconds of a break.
Absolutely, no problem. Take your time. For most of you guys, it may seem very easy to draft a memorandum, but trust me, it's very difficult. It's one of the harder things of being a muti. You'll have to fight for each argument. You'll have to fight with your co-counsels, with your teammates about each argument. And Janis can be a witness how we were fighting for each source, for each part of the memorandum. And it's quite interesting as well.
Yeah, I guess we can hopefully come to that in the end again. You said 15 minutes, right? But that's
50.
perfect as to this.
We have 50 minutes.
Ah, perfect. Then it's much better, much better.
Yep.
Then we will come to that for sure in the end, because maybe a short excursus right now, as we already now concluded this whole content. The experience that you're going to have is not that unimportant to have in mind. You will usually sit with your friends, with your team members, or maybe at a later stage, if you're not playing the Vis Moot, with your colleagues, with other lawyers, in a room, in an online conference. And everyone will work on their own stuff because you will separate it. It's just too much to do all of that jointly. Then you will present it to the others. And maybe someone within your team, hopefully, will be smart enough to notice a mistake. And hopefully he will also be brave enough to tell you about this mistake. And then it depends on you. That's something that's really important for me to say, to have the how to say it, to be the man or woman to accept to make a mistake. Because once again, this is a high art and you will do mistakes. And yeah, mistakes are just part of the process once again. That's what I want to say. And making your friends notice that they did a mistake is extremely important. And even more important it is to not feel bad about doing mistakes, about not feeling bad about being criticized, about not feeling bad about receiving negative feedback, because you will consistently face this in these 2 or 3 months. It's really hard psychologically. I was sometimes working for 60 weeks, sometimes in 60 hours in a week on my part, on my 8 pages. And after the week, I submitted it to our coaches, and I received from 8 pages, 5 pages completely deleted, and they said, please write it new. It's like, what the fuck? I was writing for that now each day for 4 hours and hours, and they just say, come on, delete it. That's bullshit. So what I want to say is you really have to be like stress resistant, and you're not allowed to have a big ego. You have to think about the product, you have to think about your arguments, about your team, and never about yourself, never about the mistakes you did, because that's just not relevant. In the end, it's relevant to have a nice product that you submit on the day of deadline. But okay, that was kind of a team building excursus, but it's really, really, really important. And you will face struggles working on complex memoranda as to exactly this point. Now let's come to the effective writing part. I guess it will take approximately 15 minutes, and then we have some time for questions afterwards. Maybe a bit longer because I'm talking a lot today. So first of all, I will talk about a principle which is called keep it short and simple. And then I will try to give you some sensitivity for also how very small things can have some impact. And that's really advanced. You don't have to master and apply that in each scene of your memorandum. But that's maybe what distinguishes those memoranda who are then really successful, maybe those top 10 memoranda from top 25% memoranda, top 40% memoranda. So yeah, I guess that's also the more interesting part here, because it's basically general persuasiveness. So keep it short and simple. I really hate starting presentations and so on with a quote, but this one is just so fitting here that I have to do it. And it's also by a German poet, so I once again have to use it. I apologize for this long letter. I simply had no time for writing a short one. That sounds paradox, but I guess we can already think what it means if we think about maybe private context. We can really fast bring a lot to the paper. We can brainstorm. But to distill it, to really only have that what matters inside, to have in the end a high quality of literature also, like he was a poet, he was not a lawyer. that takes time. That is really like a hard work to only have in the end on the text what matters. And as lawyers, just as poets, we're just working with words, with basically nothing else. So each word that does not matter is a wrong word, but we will come to that in a second. Take your time to make things short and easy. So we come back to the grading system once again. The arbitrator is back from his busy day of work, and now he reads your memorandum, and he needs to understand quickly what you want to say. What it means is that he does not want to see that you prove you are the smartest guy ever. You know all of the legal terms. You have Latin and ancient Greek and ancient Kazakh phrases everywhere, and you know all of, I don't know, intellectual fine arts world. That's really completely irrelevant here. What they want is precise arguments, quick to understand, short sentences, not a lot of ideas per sentence. We'll come to that now. Easiness, simplicity, 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 simplicity. If you take one part from this session, then okay, be precise, do everything that is expected for you, but in the most simple way. That would be already important for me. So what we have here are basically two approaches to combine that. What we want to do, and that's basically what we did in Freiburg, but sometimes we even combine those approaches, is actually having just only one idea per sentence. Ask yourself, what I'm right now saying, is that actually just one point? Or is it two different points? Is it maybe even three different ideas that I'm then going to use and explore for my further arguments? And if that is the case, that might already be quite complex to read. We know that experience, as all of us studying right now, that we sometimes have to read sentences twice or three times, but it's much more satisfying to read a book that explains it in a way that you only have to read it once and you understood it. And you want to trigger that satisfying feeling within your judges. So write it easy, one idea per sentence. And if you have multiple ideas, make multiple sentences for that. You can also do it more formalistic, and sometimes we also did it. It's a good indicator. If you have more than 2 lines for a sentence, if you have more than 20 words for a sentence, it's too long. It's just too long. It will take too much time to understand it. Such a sentence will always be read twice in a complex legal environment, because you're just talking by itself already about complicated things. So use at least a simple manner. And that's really important. I have here these exclamation marks, everything matters. Justify each single word. That's what Isian also just described. We were discussing the scholars, we were discussing the sources, but we were also discussing the formulations. If one of your teammates asks you, why did you write here this and that word? And you don't have an answer, then just delete it. And if you have an answer for that, you can justify why you wrote it, but he still says it's complicated, then split it up. And if none of that works, if you can neither delete the word, nor you can split up the sentence and thus make it easier, then you really have to think whether your argument by itself is just too complex. It's just not easy enough to facilitate. That's basically the main idea here. Just try to be as simple as possible at all times. Now we come to a bit more of like grammar lesson, if you want to. And we have even like a small excursion to psychology. Basically, we know that if we read something, we are using in the most time our real ultra short-term memory. That's basically a time frame of 3 seconds where we can remember in a subconscious phase what we previously said. If you right now think what I had as fourth word on my previous slide, none of you will be able to tell that, even though all of you saw it. And that's also like usually the case while just reading something without big focus. And they were reading more important things than your fictional competition problem beforehand. So they might not have the same attention as they had for the exhibit that they used for their actual claim 3 or 4 hours earlier. What I mean by that is it should not take longer than 3 seconds to read what actually matters for your idea, for that one idea you want to deliver in a sentence. that means we have to have a close connection in between of the subject and the verb, because those two parts of a sentence are the most important parts of a sentence. I have one negative example and one positive example here. I will read both of them out just to give it a bit of more understanding. They say the same thing up front. As a preliminary remark, it must be noted that unlike claimant repeatedly attempted to make the court believe, respondent, who has more than 20 years of experience in the construction industry and who carried out foundation works in no less than 10 similar projects, at no time failed to afford adequate protection to the foundation work against temperatures lower than 10 degrees Celsius. A. And B, exactly the same content. Respondent has more than 20 years of experience in the construction industry, full stop. It carried out work in 10 similar projects during that time. At no time, respondent failed to protect the foundation works adequately against temperatures lower than 10 degrees Celsius. There is not a single information in the first sentence, which we don't have in the second sentence. But you see, I guess, what I mean by this close connection between our subject and verb. Our subject here is respondent, and our verb is to have experience. It's coming within 3 seconds. We can remember that. Our subject here is it, in that case, the respondent, and our verb is to carry out. And it comes directly out of each other. So basically, we can go through that now here with each of the examples, and we will see that in the positive example, it's really possible to read those points within seconds. While in the first sentence, I guess none of us understood what I was telling you about. At least I was reading it out and I don't understand it still. The second sentence is really helping me with that. And there also we have our subject in the middle of the sentence. And it's just not that easy to notice it, as you might see. And also we have a longer sentence again. We have multiple ideas per sentence. So that's maybe underlining what I already said previously. Things to avoid, and it's once again the idea of keeping things short and simple. Nominalizations usually take more space. So the agreement was reached by the parties is exactly the same as the parties agreed. Mr. Creamer made an assumption. It's the same as Mr. Creamer assumed. And it's much shorter. You will have more space for actual arguments, but it's also much easier to read. And it says exactly the same. Sometimes you will just have more precise professional words, or in general, more precise words. And if you don't know that word, we would usually help ourselves by using adjectives and adverbs to describe them. For example, to say something loudly, we could also say to scream. And to have a more picturesque example, we could talk about a huge extinct animal, but we can also just call it a dinosaur, and we will save space and we will be more precise. So that's the idea as to that. What we also don't want to have is legalese. We don't want to appear super smart. That's what I said before. We can, of course, be pretentious and say there's an adequate number of scholars that is in our favor, but it says the same as sufficient, and it's easier to read, easier to understand, and it takes less space. At the present time, usually we can just say now. And during such time as, we can also say while. I'm not saying that we can never use these points, but it's better to not use them first. Of course, you don't want to be completely repetitive, but also repetition makes things easier often. So what I want to say is two things. Basically, you save space for arguments, and you make things easier to understand by not always using complex legal phrases. And another thing that you want to avoid, it's not connected to keep it short and simple right now, but spelling errors. It sounds super superfluous right now, but I would really say that 50% of submitted memoranda in the Vis Moot have spelling errors in the end. And that's just embarrassing. That shows that you were not working well enough. We also noticed one mistake within, I guess, in total 100 pages of work. And we were really, until today, we are not happy about this incident. But just avoid it. Read through it like multiple times, different persons. use apps like Grammarly or so that help you with checking things like this. And now we come basically already to the last slide of this presentation. And now it's getting more and more nuanced, basically, as you see. So we were starting with very general just presentation of what you will have to do. And then we were getting more and more nuanced in how to do that good. And now we're coming to the real details. And once again, I just want to give you here a sensitivity that words matter. We said right now that we want to combine subject and verb. But what we also can ask ourselves there up front is what kind of subject we want to use. Because often we can say different things for the same thing. We can say that one guy is Yusian Tastanbekov, but we could also say president of Kazakhstan Vis Moot Association. We could also say student. We could also say Kazakh or Uzbek. I'm sorry, Yusian. We could say different things to describe the same thing, the same person, the same company, the same legal argument or idea. I guess you know what I mean. And there's research on how this choice influences us as a reader. So what we can see is that the level of identification really can be raised with the choice of subject. So if we have a certain human being, an individual, Yusian, me, Miss Horatio Porter maybe, who was relevant in one of the Vis Moot problems, then it's a person that, or a term that we face each day. We associate human beings with that. That's very different if we talk about the company that Miss Horatio Porter and maybe Yusian are working in. We can just say the company, and that already sounds much colder, I would say. We don't have that emotional bias subconsciously as reading a certain name. And we could even abstract that more. We could go to objects. In our case, it was about drones. We don't have an emotional relationship usually to objects. And then we can go to abstractions. We can talk about buyers and sellers. Buyer and seller is even more abstract than the actual companies which were buying and selling, or the individuals within the sales and acquisitions departments of the companies. So you could really choose here out of a big sphere of subjects, the one that is most suitable for you. A small example. We could once, in case right now, we want to, I don't know, discuss on the credibility of Mr. Judge Paulson. And then it might be the very convenient way to just say, the law says that minors must not buy tobacco. That's a really neutral sentence. We could make it a bit more personal by saying a Swedish court decided that persons under age of 18 must not buy tobacco. And now we can even switch it up a bit more, and it's still saying exactly the same, but it might have a bit of subconscious emotional effect on us. Could say the judge, Mr. Paulson, decided that 14-year-old Yusian Tastanbekov is not allowed to buy tobacco. So you see exactly what I mean. It's examples right now. They are not used in a legal sphere as these examples specifically, but that's something that you can have in the back of your mind, and that will help you to really become proficient in the drafting, on a very high level. And in the best case, your judges don't even notice that you did it, and you were actually playing with their subconsciousness. That's really advanced, and that's hard to manage, but it's good to have heard about such sensitivity once and be aware of that. That marks the end of the actual presentation. That also means that I will quickly end sharing here so that I can see all of you again, not only the one who was speaking as the last person. Thank you so much for your attention. Thank you so much for the questions you were already asking. Now I have 30 more minutes to answer questions of yours if you still have them. Related to this topic, for sure, preferred, but also in general, I'm happy to discuss with you.
Sambat, go ahead.
Yep, I have a question. Can I ask?
Definitely.
Oh, yeah. The first question is, what are the most frequent mistakes while drafting memos?
The most frequent mistakes. Okay, for sure, I don't have scientific research on that, but my takes on that are first, not being patient enough, thinking that you already read everything. You basically, what we can say, your research never ended. We were spending thousands of hours on research during the written phase, and to be honest, our argument that we were pleading in the end in Hong Kong, we were researching on 3 months after we submitted our claimant memorandum, because we found something new. We thought about something else. You can spend millions of hours on researching, and you will not have read everything. So your research never ended. You have to stay patient. Second, it is for me really like inconsistency. If you use abbreviations, use them always. If you use a certain system of citing sources, a certain manner, use them always. Communicate that with your team. Read that in a crossover. You read that of your friend reads that of yours, and just mark it if it's not the standard that you agreed upon. Really try to be conform. And then, of course, there are mistakes which are more straightforward to notice. For example, not making use of all the pages that you offer to. If you're submitting a memo with 30 pages, that will be lots of work for you already to write such a memorandum, but still the judges will see that you wasted 5 pages of space, and other universities were not doing so. Those guys somewhere in Harvard or somewhere else, they were really fighting for each word, and now they have 35 pages. Don't be afraid of them. They don't do a different thing than you do, but make space. And I would really say that's a frequent mistake because, for example, the memorandum I showed you beforehand, I guess it had 19 pages or 18 pages. That's just a very bad impression. Yeah, so exactly. I hope that was maybe helpful of an answer. And I also hope that we have.
Thank you.
And I also hope that we have even more questions.
Yeah, we see Farangis is raising hand. Please go ahead.
Yeah. One more question. So, as we know, there are so many arguments, cases, and scholarly opinions written in memorandums. And while preparing for oral presentations, we know that most of the times it's a time limitation. And maybe it's a question for both of you, for Usen and you. Like, what criteria or methods did you use in order to prepare for orals and choose the right arguments or cases? Because we know that most of the participants are trying to prepare for some predictable questions by the side of the arbitrators. And for example, in the answer, we may use some cases or in the words or scholarly opinions. So what's your opinion? Should we consider most of the cases that we've read in order to be prepared for to answer a question? Or should we choose some of them, read them carefully and try to find an answer for all the questions in a few of them? I hope that you got the question.
Sorry, I just noticed that I was still muted. Yes, that's also a good question. First of all, I guess, already say right now that you will have lots of information on exactly these kind of questions in your very next session, conducted by Sebastian Reinwart. He's a real expert on public speaking and on the oral phase. He will tell you a lot about that, but I guess I can also give some advices here. I mean, in the end, you already described the outline and the basic problem. We have limited amount of time, and we were spending thousands of hours to collect knowledge. So we have to prioritize. That's our first thing that we have as a necessity. We need to prioritize. What we were doing, and I would really recommend that, is to break things down, to make things very easy in your oral submission, and thus maybe use only 1 or 2 cases actually that you describe in a broad manner. You can name more. You can say, okay, what I just described in a broad manner was also upheld, by the way, in this and that court ruling. But you will only explain, like in one case, in a broad manner, why this case was ruling what it was ruling, and why it also applies to your case, to your dispute. On the other hand, you should be prepared. And what you are having within the Vis Moot in the oral phase usually is a case bundle. That's like, or a case file. That's a summary of the problem, of your memoranda sometimes, of all of the authorities that you are citing, and also the cases that you expect the other side to argue on, or maybe that you expect arbitrators to ask you questions on. And then in the case that you do not know about all of the cases, because you cannot have all of that in your head always, that's really hard. Your teammate will open this folder for you, and he will go to that case, and he will take his pen and go to that line that was saying this and that, and you will say, okay, Mr. Arbitrator, even though I don't know it right now, here in this case file, we have it, of course, prepared, and seeing this and that, and then you can come to your point. So what I would recommend is be prepared, have everything in your case file, rather 2 or 3 more cases than you actually need. And during your proactive submission, break things down. Have everything prepared in the back, and only bring simple and straightforward things proactively.
Janis, if I may, I just wanted to suggest them the thing that you suggested us when you were our coach. So whenever you guys are participating in the oral phases with other students, make sure that you are writing all the questions that your co-counsels or your teammates are getting. And for the next time, you will have to make sure that you have the best answer for them. So by the end of the friendly rounds, before going to Hong Kong or to Vienna, you will already have like roughly more than 100 of questions. For them, you will have very specific and very great drafted answers. And by that way, you may be seem very professional in front of the arbitrators, because most of the questions will repeat again and again. So this way would increase your chances for a great performance.
Oh, well, I have a question for both Janis and Wilson. This is a question with regards to orals. I've always had this thought of whether to, on your argumentation, whether to control the narrative or let the arbitrators control the narrative, which is the best course of action.
Isian, maybe you want to go first, and then I share my thoughts afterwards?
Well, it depends. It depends on the tribunal that you have. Some arbitrators want you to lead the discussion. They want you to show everything. They want you to make sure that they are with you. But for some of the arbitrators, like they really want to be a leader. So you have to look, you have to research on your arbitrators. If you see that they are following you and they are kind to follow you on each position, it's better to lead them. But if you think that they are being too strict or they are being too principled in these specific questions, don't argue with them, be respectful, and try to be nice with them.
Yeah, I guess in general, I can underline everything Isian said. I guess in general, you want to lead because you also know more usually. You were working for months now on exactly those specified legal questions. These guys that are judging you, they are professors. They are very distinct. They were working for a long time, but they also have lots of things to think about. And they were not just focusing on this one legal question. So be confident that you know more about these questions than they do. And thus also usually lead the debate. And then to link that to what Isian said, have the ability to read the room. You can usually not research whether someone ego and wants to lead the debate or whether someone is actually interested just in your pure arguments. That's not nothing you can find in the internet. But you can find it maybe in his eyes. You can maybe find it in the way that you're talking to him and he's talking to you. And in the end, it's not about winning him. It's about making him like you. That's in the end the game. So then be able to read the step back maybe, but in general, be confident, lead the debate. That's my talk. Okay, Temirlan, I hope I was not butchering your name too much. I'm sorry. I'm still
Yes,
struggling.
thank you. I just wanted to ask about your experience and experience of your team in researching the issues. So usually the Vis Moot provides you with 4 issues, yes? 2 for merits and 2 for procedural. And I wanted to ask is it efficient for you to divide the team on 2 groups, one researching for merits and the second researches for procedure, and then each of the person like research for only one issue. I know that your team was consisted of 8 people, so it was maybe easier for you to research. But do you recommend for team of
Yes.
4 people to research on like one person research one issue, or 2 people research on both issues?
It's hard to give a plain answer to that. To maybe give like exactly the context, back then with 8 of us, we were splitting up 2 persons per issue. And that had the advantage: first, you can really focus on one legal question, you will be an expert in that. And second, you still have someone to discuss it with. And that's extremely important to have someone to discuss it with, because otherwise you might go in a completely wrong direction. That's happening. And you might notice that only 3 or 4 weeks in, and that's good to have someone telling that to you. So that was a very convenient situation, no doubt. Last year we had 4 mooties when I was coaching Lucien and so on. And still we were doing it the same. We were separating them into specific issues. But for sure, we always had this idea, because it's just lots of things to keep in mind. But still, we always have this idea of having checks and balances, basically, making cross controls, sending one presentation or one draft then to another person who's also working on procedure, and asking him to give feedback once, and so on. Because you have advantages and disadvantages. Advantage, specification and depth of the research on that one point. Disadvantage is lack of control, lack of maybe sometimes the assurance that 2 people agree that things are going right. And also consistency. The memorandum in the end has to appear as if it was drafted by one body, by one law firm, or by one lawyer, maybe by one person. That's an optimal memorandum. You should not be able to read, okay, that was drafted by this person, that was drafted by another person. And the more you separate, the higher this risk gets that it's noticeable. Or if you then are proficient enough to mitigate that risk in the end again, the more time it will just take to mitigate that risk. So that's basically what you have to have in mind. And then it's very individual. It depends on the persons. Maybe sometimes you have teammates which are just a bit like they're good in oral presentation, but not that good in their research. And then you might notice, oh, it's not the best idea to keep them alone on an issue. I would say the best thing I can say to that is being aware of the pros and cons. But in general, we were always specifying. Perfect. Farangis, please repeat your name once as it is properly.
It's okay. So one more question. It might be a bit out of question, but I'm really curious about it. So while you're preparing for rebuttals, should you consider the counterparty's memorandum in order to prepare for the questions for them? Or is it better to like sum up all the arguments that they made during the orals and try to create a new question while the oral?
Yeah, I see. So the rebuttal for everyone who was now maybe not that far already is exactly this very last part of a debate in the oral phase. Someone was making their submissions for 14 minutes, and now you're able to answer for 1 minute on that. And while maybe usually we would take into account what we have written in the memoranda beforehand, that's a different situation in this competition of a moot situation. The arbitrators that are sitting there and judging you in Hong Kong are not the same as were reading your memoranda. So they were usually not reading your memorandum. So if you then make a point on their submission, written submission, your judges will just not know what you're talking about. So clear answer, you will always go on a point that was raised within these 14 minutes. You will rebut a point of their oral submission.
Thank you.
Janis, we had one question in the chat from Ahmed Ajvat. Do you see the chat, or do you want me to read out it?
Give me a second. From whom was the question again?
Mohammed Ajvat at 829.
Yeah. 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 So first of all, I'm sure that Sebastian will give you lots of details to that tomorrow. Not tomorrow, I guess, but in the next session. Sebastian can tell you when exactly it is, and you probably know it better than I do, because that's exactly the point of this whole presentation. You will get exactly these questions answered. In general, it's a very hard timeline there. What we are doing is just practicing, repetition. And so for everyone who did not understand the question first, the question was, when done with the submissions, when basically the written part is concluded and you start the oral part, how to manage this transition to be that concise and only have a few minutes to address your points. What we were doing is challenging our teammates often with telling them, okay, you have now 30 seconds, please make your argument. You have 1 minute, please make your argument. And that was going hilariously wrong in the first times. People were just starting to explain the parties and so on within 30 seconds. So no one was able to understand the argument. But after sometimes you will be able to make your argument within 1 minute, within 2 minutes. And I would train myself by limiting myself even more than, like, try to say your sentence or argument within 1 minute and just make a hard cut after 1 minute. You're not allowed to say one more word. And then people will tell you, okay, come on, I did not hear your argument so far. So you have to come to the point more. And that's what you will learn during the oral phase, to come on the point, to specify what is important and what is not important.
Well, that's relatable. And we have another question which says, what's the major difference and similarities in this memorandum and the memorandum in real cases?
So first of all, to be fair here, I mean, I'm working in a law firm for 2 months so far. So I saw some submissions right now, but I'm right now sitting on the third submission that I have. And also the experience that I have is quite a special one, because we are working on quite complex cases, which then differentiate to a Vis problem already by just the sheer size. So this week we had a submission in a big dispute where we had 240 pages of pure text. And all of these 240 pages follow the rules that I explained to you in those last 1.5 hours. It's a crazy matter of work. It's 20, 30 professionals sitting there for months, sometimes for years. But that's the second difference right now. Usually in a real arbitration, you have less time to focus on something. So what people sometimes told us is, like, this memorandum you will submit here right now, it will be the best memorandum you ever submitted in your life. Even if you're a partner one day, you will just not have the time to focus that much, because you will have also a business to run, or you will also have a different client, or the tribunal just says you have 1 minute for 1 month for submission and so on. So you have external pressures that allow you not the quality of work sometimes as it is allowed in the Vis. In total, things are very similar. You also make your arguments, you also have the same structure, you apply the same rules I was explaining in the last 1.5 hours. But yeah, you're maybe just a bit less playful sometimes. You're a bit more serious sometimes, even more serious than we are. Yeah, but once again, the biggest part is very similar.
And the next question is from Violetta. What is the most valuable lesson you have learned at Vis?
There are lots of them. That's hard because I guess it's also very subjective. It depends on where you were coming from. I guess for me, it is really to have a right to be confident. If you I guess maybe lots of us you can relate. We are all on basically similar status right now. This legal world always seems kind of like an ivory tower. It's very prestigious. It's very old of a profession. So some people seem to be very distinct and very far away from someone. And what really was I guess the biggest push for my career so far, but also for me personally, is to see, okay, in the end, all of them, as just you also are human beings. All of them are boiling also with water, as we are saying in German sometimes. All of them, yeah, have the same preconditions in the end. Some are smarter slightly than others, okay, but that's really not the decisive part. What I want to say is a lesson is if you put work into something, and if you then understand this by yourself, there is no reason not to have the confidence also to bring that outside and to make something out of that. So you can consider yourself to be an expert much earlier than you might think right now. That's something I learned during the last 1 or 2 years for sure. If you read on things very specifically, you will know much more about these things than the broad average. So yeah, I would say a justified reason to be confident is one of the main things that Vis learned me, and patience. Yes, we have one more raised hand I just saw.
I can't pronounce that name. Yep, Ali, go ahead.
Hello,
Hello,
sir.
yes.
First, I want to thank you for your great lecture. And I have a question. I want to know what is your actually recommendation to get better at writing our summary or memo using IRAC or CRAC method?
Practice, and repetition. Yeah, I will tell you a very practical approach as how we did it in Freiburg, and we had very good preconditions as it was already noticed by you previously. What we did back then was having Monday, first day of drafting. On Friday, 5 days later, we submitted 35 pages. So after 5 days, when the Vis Moot started, we were submitting 35 pages. And then we will give it to our coaches, and the coaches were saying, come on, that's complete nonsense. And they said, write all of that again. And we were doing on the next Monday the same again. And on Friday, 5 days later, we were submitting once again 35 pages after deleting everything. And the same on the next week. And I can tell you the same on the next week, the same on the next week, the same on the next week. But after week 5, they were saying, oh, wow, that point is actually good. That can stay. Or we were saying, no, come on, we were writing that point now each week because it's important. We want that to stay. What I want to say is repetition. If we read now our drafts from first week, it's like a comedy session. It's really bad. It's really bad. And it's also making you proud then afterwards to compare that to your final draft, because that's actually like the growth that is awaiting for you if you go through that long and maybe sometimes also burdensome and stressful way, but it will pay off in the end. Just do it more often. That's with every skill, by the way.
Thanks.
You're welcome. Okay.
Well, I have another
Yeah.
question to Janis. Well, some of my students from MNU thinks that I'm giving too much tasks right now. And just to compare with the Freiburg, what was your schedule when you were attending in Vis Moot? How much time have you spent a day for drafting memorandum, for researching, and for preparation to oral phases. Could you just elaborate how, like, European, how most of the German teams, how they deal with that?
So, I mean, I right now saw, I guess, the approaches of different universities, different countries, and cultural backgrounds, and to explain maybe also how they arise up front, one or two sentences. First of all, each country has a different priority on the Vis Moot. Like as a student, there can be different incentives to participate there. If you don't have a big arbitration community in your country, or let's say not a big, but not a growing arbitration community in your country, it might not be very interesting for you to spend thousands of hours in such a thing. If you already have a well-established community in that, if you already have nice links to the professional work, that will really pay off. So countries where you have already like established arbitration procedures, arbitral institutions, often tend to put more effort into the Vis than others. That is reflected, for example, that in Germany, we have this approach quite often that students participating in the Vis Moot do not have to take other lectures. It's like a complete time-filling activity. And that also meant that we were actually sitting in office at least 8 hours a day, usually in the intensive period, sometimes 12, 13, 14 hours. And of course, not being productive all the time, but just thinking about it, working. And yeah, in the submission weeks, we were never going back home earlier than midnight, to be honest. So it's really work intensive. But also I can say we were not doing anything before the problem was released back then in Germany. And I guess no university does so. That's something that we were trying back then to do with Central Asian students, with Jan and so on also, to kind of equal that. So we were trying to give them courses on arbitration beforehand, similar as you just have. We were trying to give them some small tasks and catalog of questions where they can start researching on, so that when they start working on the Vis, they already have a better background knowledge. And I can really tell that all of the Mooties I was working with last year had much better of a knowledge when the problem was released than I had when the problem was released. But of course, then time will at some place take care for that. So yeah, I mean, you have to work hard. You will face other universities working really hard if you want to be successful. I was always asking my team when I was coaching, what is your goals? Do you want just to travel to Hong Kong once and meet the law students? Then we can go very relaxed. Or do you really want to learn something? Do you want to strive for success, not only in this competition, but maybe also in your later careers, and really learn something right now? Show someone in your next internship that you were doing something like that, and they will be surprised by your drafting skills. Then you have to spend time. It just does not work otherwise.
And thank you for this great answer. And I have follow-up question. What do you think about, like, what would you suggest to students from developing countries that think that students from developed countries are more smarter or more likely to win the Vis Moot? So what would you suggest to those students to increase their chances?
So last year, Freiburg was not, like my university from Germany was not making it to the round of 32. But the Kazakh university was doing it in Hong Kong. No, I mean, that's just a joke. They are very smart, all of Freiburg team as well. It's very subjective in the end. No, what I want to say is that's complete nonsense. I mean, the point that is in the end different is the level of guidance, the level of persons that want you to succeed and that know how you will succeed in the end. That is different. And that is also realistically different. We have lots of people surrounding us in the German universities that are not telling us what to do at all, but that are telling us what is wrong, for example, that are listening to our arguments once or twice. And they are not writing a single word for us, but they at least make us aware of things which are not going right. That's different for you usually. And that's exactly why some people try to establish that right now. The CLDP is sponsoring there. That's a big sponsor, and they provide you with really good opportunities. So being part of that program is like you're really not that disadvantaged as other countries participating in the Moot are. And finally, finally, just be confident. Do it. As I just said, as soon as you research on things and understood them, then you're also qualified to speak on them. And there's not a reason that anyone, just because of a different origin or so, would know anything more about them. Etienne was proving them that last year to lots of students in the competition, which thought they might face, just not well known in Europe at least, university from Kazakhstan, and then they were destroyed time after time after time. That's satisfying. Just be confident. Okay.
Janis,
If there are further,
apologies. Well, it seems like Mohammed didn't hear your previous answer to his question. That's why he was wondering whether you can answer it again. So the question is, when done with the submission of both claimant and the respondent's memorandum, what would you recommend for preparation of arguments? Do you remember that question?
Yes. So first step, long answer will be on YouTube soon. Second, short answer, just practice. What we were doing back then, it's a very hard change. What we were doing back then is challenging our mooties with giving them only 1 minute to make the argument instead of 14. And that's going completely wrong in the beginning. But at some place of time, you will be able to distill what is really important. And that's the whole challenge of the oral phase then afterwards. Practice, and limit yourself more than you have to. It does not have to be 1 minute, but it can be 4 minutes, 5 minutes instead of 14. And then you will come to the real core ideas that you want to make. And then you can build on that and make a nice submission out of that. Okay.
Well, that was an excellent answer as well as excellent session. Thank you, Janis. We really appreciate your willingness to help us in this journey. I think each and every student here enjoyed and will have better opportunity to draft decent memorandum for the selection process in their respective universities. I hope you also enjoyed the session with us, and thank you.
Most definitely. Yeah, thank you so much for your attention, for your participation. It was really nice for me as well. Make sure that if you're interested, you connect to me. You can find me on LinkedIn. And if you have any questions during your preparation, also in the competition, feel free to reach out to me. Thank you, Etienne, for organizing all of this. It's a great endeavor. I'm really happy about seeing this. And once again, thank you to all of you participants. You are in a great way. The mere fact that you're interested in this, that you're sitting here at 9 p.m. of your time and thinking about these things is already a big sign. It's very impressive for me. You're in a great way. And yeah, I'm looking forward to maybe meet some of you in a few months in this framework again.
Absolutely. And the last thing that most of the students were asking whether they can receive your PPT presentation, whether you can send it.
Definitely. No
Wow, nice, cool. Well, it was nice to see you, and thank you again for being with us, and bye-bye.
Goodbye, have a nice evening.
You too. I hope everyone filled their registration and the attendance form, so we can just stop the meeting unless there are any remaining questions. Cool. Well, it was nice to know you. Jalan Vic. Go ahead.
Can I say the previous assessments, previous tasks which you give us?
Yep.
Can I send email?
What do you want to send?
I mean that in the LinkedIn previous task which you give us.
I didn't get the question. Do you want to submit a new one or what?
Previous task, which you give us.
Yeah, you already submitted one, if I'm not mistaken.
Yeah. I want to send previous task. Can I?
So you want to send a new one or what?
Previous, which you give us in the mail. I just cannot.
You mean in the MNU
Yeah.
Vis Moot channel? Well, please text me on the private message. This call is only for arbitration summer school, and we
Okay.
are going to answer all the questions about summer school here.